libertarianism is pro-immigration, pro-market, pro-trade.
More competitive, less centralized. Not military confrontations, but peaceful interaction.
The war on drugs has been actually an unmitigated disaster.
Hello, everyone. Thank you for coming out tonight. I want to give a special thanks to Students for Liberty and the Republican women of Cape Coral Federated for the reception today. There are many groups who came together this week to ensure success. Before we get started tonight, I wanted to state again what our goal was with Second Amendment Week. It's not a protest. It's to represent the conservative and libertarian students' viewpoints that have been drowned out in the coverage of March for Our Lives in the aftermath of the tragedy that occurred at Marjory Stoneman Douglas High School. However, although we want to showcase our views, we recognize how desperately needed bipartisanship is in coming up with solutions towards gun violence. We have organized this week to showcase our side and bring together as many different viewpoints on this issue as possible. Tomorrow evening, at this time, we will be hosting a panel on the Second Amendment and gun control. The panel will feature the chairs for the Lee County Republican Executive Committee and the Democratic Party of Lee County, the president of the Southwest Florida Pink Pistols, which is an LGBTQ gun advocacy group, an activist with Moms Demand Action, the former FGCU campus ambassador for the NRA, and a current Marjory Stoneman Douglas student who is part of their JROTC program. Then we will host a Socratic discussion on these issues on Friday, where we will encourage and welcome a peaceful and productive open exchange of ideas. We are hardly here to shove our views down anyone's throats. We just want to open up the dialogue for civil discourse, and we are excited and encouraged to facilitate something that fosters unity over division. Now I'd like to introduce our speaker for tonight. Before I kick off his introduction, I want to express my deepest gratitude towards Bob. This is the third time he's come to FGCU this semester. Bob Levy is chairman of the board of directors at the Cato Institute. He joined Cato as a senior fellow in constitutional studies in 1997 after 25 years in business. Bob is also a director of the Institute for Justice and the Foundation for Government Accountability. He received his PhD in business from the American University in 1966, then founded the CDA Investment Technologies, a major provider of investment information and software. At age 50, again that's 50, after leaving the CDA in 1991, Bob went to George Mason, where he was chief articles editor of the Law Review and class valedictorian. He received his JD degree in 1994. The next 2 years, he clerked for Judge Royce Lamberth on the U.S. District Court and Judge Douglas Ginsburg on the U.S. Court of Appeals, both in Washington, D.C. For many years, Bob was an adjunct professor of law at Georgetown University. His writings have appeared in the New York Times, Wall Street Journal, USA Today, Washington Post, National Review, and many others. He has discussed public policy on national radio and TV programs, including ABC's Nightline, Fox's The O'Reilly Factor, PBS's NewsHour, and NBC's Today Show. Bob's latest book, co-authored with William Meller, is The Dirty Dozen: How 12 Supreme Court Cases Radically Expanded Government and Eroded Freedom. Bob served as co-counsel in District of Columbia versus Heller, the successful Supreme Court challenge to Washington, D.C.'s gun ban. This bio just briefly touches on the impact of Bob's work, but ladies and gentlemen, please welcome Bob Levy.
It's great to be with you. It's good that you all have copies of the Constitution. I remember when Iraq was, we were helping Iraq draft the new Constitution, and some wag said, you know, look, why don't we just give them our Constitution? It's worked for 200 years and we're not using it anymore. Now, there's some truth to that. Tonight we're going to talk about one of the provisions in the Bill of Rights that we are using. The Second Amendment. So thanks very much for the invitation. I'm happy to be with you. We're going to talk about gun control in the aftermath of Parkland, and I plan to cover 4 topics. The first is a quick summary of what the courts have said about the Second Amendment. The second is a recap of the data on gun-related violence hopefully without getting mired in a swamp of conflicting statistics. Third, I'm going to be examining various gun control proposals that have been floated. And fourth, take a look at where we go from here. One widely cited survey indicates that there's overwhelming support for additional gun regulations, but as you all know, these surveys are sort of unreliable. Last year there was a poll showing that 60% of Americans favored a referendum on whether to raise taxes on the rich. And then a month or so later they had another poll that indicated that 65% of Americans didn't know what a referendum was. So these polls should be taken with a grain of salt. Let me begin with two key Second Amendment cases: District of Columbia versus Heller and McDonald versus Chicago. Heller was filed in 2003 by me and two other attorneys on behalf of 6 law-abiding D.C. residents who wanted to possess a functional firearm to defend themselves. So Heller was not about machine guns. It wasn't about these so-called assault weapons. It was about the right to own an ordinary garden variety gun, pistol, in the home for self-defense. As you may know, off and on over the years, Washington, D.C. had reclaimed its title. It wasn't just the nation's capital, but also the nation's murder capital. The D.C. government had been totally ineffective in disarming violent criminals, but at the same time, D.C. did a really superb job at disarming the decent, peaceable residents of the city. For starters, no handgun could be registered in Washington, D.C. And even if you had a handgun in 1976, when that law was first passed, 42 years ago, even if you had one, it would be grandfathered and you could keep it, but you couldn't carry it from room to room in your own home without a permit. And D.C. had not issued a permit in more than 30 years. And if you had a rifle or a shotgun, it too could be kept. If you had it in 1976, you could keep it in your home, but it had to be unloaded and either disassembled or trigger locked. So unless you plan to club somebody over the head with it, in effect, nobody in D.C. could possess a functional firearm in his own residence. Well, thanks to the Heller case, those laws, all of them, are now repealed. Washington, D.C., however, was not the whole story. The second big case was McDonald versus Chicago. It was 2 years later in 2010, and it determined that the Second Amendment applied not only to federal jurisdictions like Washington, D.C., Guam, Samoa, Puerto Rico, the Virgin Islands, but also it applied to states and localities like Chicago and the state of Illinois. D.C., of course, is not a state. It's a federal enclave where Congress exercises total legislative power, and that's one reason we filed the Heller case in Washington, D.C. We didn't want to deal with the question of whether or not the Second Amendment applied to the states. We simply wanted a four-square declaration of what it was that the Second Amendment means, that it secures an individual right. Until the 14th Amendment was ratified, this is 1868, the Bill of Rights, including the Second Amendment, applied only to the federal government, not to the states. So note that the First Amendment, for example, says Congress shall make no law violating certain of our rights. It doesn't say anything about states making laws. Now, unfortunately, we discovered after the first 70 years or so that the states can be just as tyrannical as the federal government, slavery being the obvious case in point. So we fought a civil war and we passed 3 post-war amendments, including the 14th, which was used to apply, the technical term is incorporate, the Bill of Rights to the states. Incorporation, however, did not occur in one fell swoop. It was accomplished provision by provision. So there'd be a lot of case law about free speech, and then free exercise of religion, and then protection against unreasonable searches, and on and on. And remarkably, until 2010, the court had never addressed the question as to whether the Second Amendment applied to the states. That's what the McDonald versus Chicago case addressed. Now, the criterion for incorporation, the fact that determines whether or not a provision in the Bill of Rights is incorporated, is whether or not the right is deemed to be fundamental. And that depends in turn on whether the right is, and these are legal terms of art, the phrases are implicit in the concept of ordered liberty or deeply rooted in our nation's traditions and culture. So the right to bear arms, the court determined, was indisputably fundamental. The court said so in Heller, the court said so again in McDonald. Now what that means is that the Second Amendment, like virtually all of the other Bill of Rights, does now, after this McDonald case, does now apply to the states and not to just federal enclaves like Washington, D.C. And what does it mean to say that a right is fundamental? It means that the burden shifts to the government to justify its regulations. So it's no longer up to me to show that I need to have a gun. It is now, as a result of the characterization of this right as fundamental, it is now up to the government to demonstrate that it has a need to limit my Second Amendment rights. On the other hand, no one believes that gun rights are absolute. The Second Amendment quite clearly does not guarantee the right of an 11-year-old to carry a machine gun in front of the White House when the president is strolling on the front lawn. So some weapons and some persons and some circumstances are subject to regulation. And that is the same framework we have for other rights. For example, even though the First Amendment says no law abridging freedom of speech, we have laws that prevent falsely shouting fire in a crowded theater, laws against incitement to riot, lying in commercial advertising, defamation, and on and on. So neither the right to free speech nor the right to bear arms is an absolute right. They can be regulated, even though both of them are constitutionally guaranteed. So what about the impact of these two cases, Heller and McDonald, on the multi-victim killings like Parkland? Well, Heller concluded that the Second Amendment secures an individual right to bear arms in the home for lawful purposes. But Justice Scalia, who wrote the opinion in Heller, and by the way, it was a 5-4 opinion, a very narrowly decided case, Justice Scalia, who wrote the opinion, explicitly noted that the opinion did not, and this is a quote, does not cast doubt on longstanding prohibitions on the possession of firearms by felons and mentally ill, or laws forbidding the carrying of firearms in sensitive places, such as schools, or laws imposing conditions and qualifications, such as background checks, on the commercial sale of arms. And then he also noted there was historical support for prohibiting the carrying of dangerous and unusual weapons. So the state of Florida could have adopted any of those restrictions that I just mentioned without violating the Second Amendment as Justice Scalia interpreted it in the Heller case. As you know, states can always grant gun owners more rights than the federal government does. The federal Constitution is a floor, and state laws and state constitutions can give gun owners more rights. And that, in fact, is what Florida has done. So Florida imposes fewer restrictions than would have been allowed under the Heller case. Now, by contrast, there are some other states that regulate or even ban, for example, so-called assault weapons or high-capacity magazines. And those regulations have not been overturned by the courts. So far, those regulations have been deemed to be consistent with the interpretation of the Second Amendment in the Heller case. So to recap this, from the beginning, this battle for gun rights was structured as a three-step process. Step one was determine the meaning of the Second Amendment. That was completed in the Heller case. The Second Amendment secures an individual right, not necessarily connected with militia. Step two, determine where the Second Amendment applies. And that was completed in the McDonald case. Second Amendment protections apply everywhere in the United States, not just the federal jurisdictions. Step three, what gun regulations are still permissible? So that's the next major task. The right to bear arms is subject to reasonable restrictions, like the restrictions that have limited other provisions in the Bill of Rights, including free speech. The key to it is this: government bears a heavy burden to justify any regulations that it proposes. So that's the constitutional background. And to the extent you have more questions on that, I'd be happy to answer them when we're finished. So let me turn now to the data on gun-related violence, starting with the elephant in the room, and that is these horrific school shootings. So this past October, Senator Chris Murphy from Connecticut claims, this is a quote, already this year there have been more mass shootings than days in the year. So can he possibly be correct about that? The FBI defines mass murder as 4 or more victims slain in one event at one location. So starting with that definition, the Congressional Research Service reported that from 1999 through 2013,